A UDA-nominated MCA has suffered yet another setback after the Meru High Court upheld a January ruling by a lower court that found his nomination to Isiolo County Assembly flawed. Kelvin Mbuthia had been nominated to represent the minority communities in the assembly, but the process was challenged by one Fatuma Abdullahi, who in September filed an election petition to have the nomination declared null and void on grounds that her name was illegally replaced with Mbuthia's.
Jina ya Fatuma Abdullahi ilikuwa ya kwanza na akaendelea mpaka dakika mwisho. While delivering judgment on the matter and ruling whether Mbuthia qualified to be nominated to Isiolo Assembly on January 17th this year, Isiolo Chief Magistrate Lucy Mutai said only those registered to vote in particular counties could qualify for nomination to respective county assemblies. The respondent had, according to court, proven to be a registered UDA member at the time of party nomination, but did not provide evidence to show his polling station. For one to qualify for nomination, he or she must be a member of the political party as at the date of such nomination and be a registered voter. Magistrate Mutai also agreed with the petitioner that the Independent Electoral and Boundaries Commission (IEBC) failed to carry out its duty to ensure that nominees in the party list were qualified for nomination to Isiolo County Assembly, and consequently ordered the agency to reallocate the seat to Fatuma Abdullahi. IEBC had in its court submission said Mbuthia was picked for being first in the UDA party list and insisted that its role was to entirely supervise party list and verify that the nominees were registered voters. Following the judgment, Mbuthia moved to the High Court in Meru, seeking an injunction and suspension of orders issued by the trial court, including nullification of his position. Justice Dripsiza Cherere thus sustained all the orders by the lower court, including nullification of Gazette Notice number 10712 of September 9, 2022, that gazetted Mbuthia as nominated MCA, and the order to IEBC to reallocate the seat to Fatuma Abdullahi. The order for cost was also upheld, with the appellant ordered to also pay UDA party costs of appeal not exceeding shillings 500,000, with the party and IEBC also ordered to shoulder their own cost of appeal. Mbuthia had hoped to protect his seat with Section 371 of Elections Act that states replacement can only be done if a representative from a political party dies, withdraws from the party list, changes parties, resigns, or is expelled from the party during his or her term of representation. But Justice Cherere said, I quote, while the section was meant to ensure transparency in allocation of the seats so that only qualified members in terms of priority are considered, it does not mean an illegality like the one that happened to Fatuma has no remedy in law. Further, she said, I find that the reallocation of seats is available in merited cases like this one, and that the trial magistrate correctly interpreted the act. End of quotes.